Well, good afternoon, everyone, and welcome to today's webinar. This webinar is in partnership between the United Church of Canada's EDGE Network and also Small Business Solver. It's part of our social enterprise series, an effort to provide resources for leaders and social innovators to provide tips and fill in a bit of the gap in what we've heard are some of the topics that seem to be currently missing from that type of resource library. So I'm thrilled to be joined by Rajah today, Rajah from ClauseHound, who is going to be providing some legal tips and specifically walking us through the top 10 tips for hiring a contract employee. As participants in this webinar, you should be able to hear both Rajah and myself. However, we can't see or hear you. So we'll really rely on this chat space to be in discussion and dialogue. At any point throughout the webinar, please use the chat space at the bottom of your control panel to pose any questions, any comments you have. I'll be monitoring that space and we'll do our best to get to all your questions and comments today. So don't wait for a break or when we give a gap for any questions. Just type anything you've got and I'll make sure that those are voiced throughout our time together today. This webinar is being recorded, so after the fact, you can re-access the link as a participant in the webinar. You'll be receiving an email that will be sent out as a follow-up after our session today, and it will have the recording link in it. You can also feel free to share that with anyone else that you think might be interested and find this a valuable resource. All of our webinars are up on YouTube. We have a YouTube playlist with everything in our social enterprise series, and we're really excited to be building that library. So I think that's all the housekeeping from me. I am at this point going to turn things over to Rajah. And Rajah, maybe you could first let us know a bit of who you are and a bit of your background and what brings you to this topic today. So welcome, Rajah. Really glad to have you here.
Hi, everyone. Thanks very much, Lauren. So I guess just to give you a little bit of background on me, I'm a lawyer, and but I think above that, I'm also an avid volunteer, and I think that's probably one of my strong suits and maybe a weakness as well. I'll pretty much say yes to anything that's asked of me. So when Lauren asked if I could come and present on this topic today, I said sure. So in terms of the not-for-profit industry sector, so I myself started a not-for-profit about 6 years ago. I'm co-founder of a company called Multiplicity, and Multiplicity is it's a technology entrepreneur education website and event group. We've probably hosted about 200 events in the past 6 years, and we send out a weekly newsletter that helps people navigate the world of entrepreneurship and tech. So in building this company, I really got a sense to dig into a lot of the issues in business law that are specifically related to charity not-for-profit foundation. And I'm also the founder of ClauseHound.com, and I thought I'd play a quick teaser video just so that you guys can get a sense of what we do. You'll hear my ukulele in the background. I'm just kidding, that's not me playing. Let me see if I can stop this. There we go. So just to sort of bring us back to the topic that we're here to talk about today, we're here to talk about hiring contractor employees at a not-for-profit. And the reason I'm sort of showcasing this through ClauseHound is because ClauseHound was built for the purpose of democratizing legal drafting by creating a portal that sort of really helps to educate folks and bring them up to speed on a new language for a lot of people, which is contract drafting. So we'll use the software today and sort of step our way through a contractor agreement. And I think you'll get a flavor for the language of drafting, and as well as the approach that I might take if I was drafting an agreement. So I'll pop right in. So you'll notice that the look and feel is a little bit different than in the video. We launched a redesign on Friday afternoon, which was a couple of months in the making. So pretty excited to see what the experience is like today. So anyway, I'll start by when I first think about hiring an employee on behalf of my clients, or even if we're trying to hire, I usually try to think of a couple of things. Like I'll try to think about what are the risks to us, what are the benefits to us as the employer, and what are the risks to the contract employee, or I should say contractor, because I don't want to use the word employee, and the benefits to the contractor. Maybe I'll change this to hiring party. So why am I doing that? Because it might not be the case that you're hiring an employee, and in this case we're actually specifically thinking about a contractor agreement. So the idea might be instead that you're hiring someone on a short-term contract that doesn't come along with all the employee obligations that a more, I guess, long-term employment agreement would contain. Okay, so risks to us, benefits to us. Maybe we'll start with benefits. And why am I making this list instead of just digging right into our agreement? Well, the reason is because what I'd like to do first is think about what do we care about, and then to look at the agreement to make sure that it contains those clauses, and then finally to look at the agreement, the precedent that I might be looking at to see if I missed anything. And so if I start with what I care about, or what our client cares about, then I think the idea is that you're not going to miss the stuff that you might have possibly missed if you're looking at a framework that might not contain the interests that you have. So I don't want to spoil the creative process by looking at the wrong framework. So okay, so what am I thinking about in terms of benefits? So we want something accomplished. So there's probably some sort of scope of work or services. We need to get it done by a certain deadline. So let's just put that in as an item. We have to figure out how much to pay. So compensation. We probably want to worry about expenses and some sort of like cap, if any. And probably on the employer side or the hiring party side, there should be some sort of cap or maximum. What else do we want to worry about? We want to make sure that our confidential materials stay confidential. We want to make sure that we own the work product, so that the intellectual property is ours because we're paying for it to be developed. I'm going back and thinking about the scope of services, work and services. We probably want to know like where the person is working. So are they working at our location or otherwise? So location of work. And then we also probably want to know that we can expect this person for certain hours of the day, so hours of work. That's a pretty good list. So let me just think about risks. And there will be some duplicates here, which I think is fine. So risks to us is that that confidential information is leaked, possibly, and that if we're talking about a not-for-profit charity foundation, it's no different than any other business. We'll want to make sure that personal information is protected. We want to make sure that financial information is protected, and then possibly other. But other risks, well, we don't want the person that we hire to do something to harm others. So we're worried about liability that we might take on, and we might want to include some sort of indemnity depending on the purpose that this person is hired for. And the purpose of an indemnity clause would be to be compensated for some action that harms others, that causes a problem for us as the hiring party, as the not-for-profit. So that's pretty good on risks, I think. If we think of something else, we can add it. And then risks and benefits to the contractor. So right up front, obviously the contractor will want to get paid, maybe recognized, and then recognized has some aspects of intellectual property ownership. Intellectual property ownership. It's to the contractor. The contractor probably would worry about such things as not getting paid. So I think we have that covered under getting paid. Maybe reputation, and that's a risk for us too, as the hiring party. So we can put that up here as well. Another risk to us as a hiring party is that the contractor doesn't know what they're doing. So like some sort of minimum standard of competence in whatever activity. Okay, so I think we had a pretty good list here. So the idea then is that we can take this list and use it to build out the agreement. So if you take a look, and I'll just click on summary so we can take a look at this agreement at a high level. Within ClauseHound, we have a series of contractor agreements, and each of them will have different purposes. Some will be short, some will be long, some will be used for specific types of hires. In this window, we can see that this is a basic agreement, and that any services or scope of work would be attached as a separate schedule. So I think what we'll do here is we'll just sort of do a scroll from beginning to end. And as we scroll through here, you can see that it is a super short form agreement, 13 clauses, easy to sign, probably easy to read. And so the idea around these types of short form agreements is that the user isn't going to, I guess the counterparty isn't going to have trouble going through it and deciding whether they want to sign. Now, most folks have seen contractor agreements that are short and long and somewhere in between. It really comes down to a few things. One is risk, and so I guess the bigger the risk to the hiring party, probably the bigger the financial obligation that the hiring party is making, the more deep these contracts will be. So I want to also bring your attention to the left side of the screen. So you'll notice that there's a little chart that includes commentary variations and so on. So what this is giving us is a snapshot of all the custom clauses that we can pop into the agreement. So although this is a super short agreement, it doesn't mean that we can't add in all the pieces of the puzzle that we need. And we're going to do that over the course of this exercise. So why don't we start with working through some of the risks that we discussed. Compensation is the first thing that pops into my mind when I'm thinking about hiring. Probably the first thing in most people's minds. So if we take a look to see whether there's a compensation clause, there indeed is not only a compensation clause, there's also a deep vein of knowledge around that point. So we're able to, as a drafter, read through and understand the levers that we can pull and push when we're drafting. It could be we might desire to pay somebody on a monthly basis or a hourly or daily. So some of these levers are things that we might not have an answer to right away. So in that case, I might even just drop in a question. They are going to pay on a daily, monthly, hourly. What other questions might we have? We might want to know whether there's a minimum number of hours per week. So I'll just write that in. We might also want to know whether we're being invoiced weekly or monthly. So these questions we might not have the answer to up front, and so I think it's a good practice just to sort of go through and think about these issues and levers. And you'll see some other notes here about bonus compensation. So we don't know. I don't know in this situation what the context is, but it's possible that you might have some sort of initial compensation and then bonus compensation as well. I'm just going to pop into the GoToMeeting and just see if there's any questions that are popping up. So far, just some more greetings and hellos. So I'll pop back in and I'll continue our chat and our thinking.
Can I, Raja, just jump in for a second, Lauren here? Yeah, we don't have any questions popping up yet. Feel free, anyone, to voice your questions or type your questions there. So someone just kind of like really starting from the basics here. So someone's using the ClauseHound platform here, and we would go. I mean, we've started off with you, and we've got this contractor document that we're starting from. But is there a way to show us kind of what before we get to that, how one would even find that document, or how to, when we go in, like how to know what we're navigating for?
Yeah, certainly. So what I'll do is I'll just pop over to this screen. So this is the initial screen for ClauseHound.com, and you can see that there's like a little slider bar that'll give you options, and you can search as well for a contract.
Gotcha.
If you click on View Documents, then it gives you sort of like the full library. Oh, this is giving me the dashboard because I've already logged in. But if I hadn't logged in, then you'd see a library list of all the various agreements that are within the software. And if there's something in there that we don't have, just email us and let us know. We've got a queue of a few hundred agreements that we're posting into the site, and so for our pro customers, we'll post something within 7 days. And for the non-pro customers, we'll sort of do it in sequence, but it really does help if we know what you're looking for, because then based on like the number of requests, we're kind of posting a dozen a week, and it sort of helps us to prioritize our own posting schedule.
Phenomenal, yeah. So for the purpose of our topic today, then when you showed the dashboard, there was that contractor agreement that popped up, and one would just click on that, and it would take you into kind of more the nitty-gritty of what you're showing us now?
Yeah, it takes you directly to here, and it'll bring you to the summary page so that you have like a high-level view of what the contract's all about. So on the left, you'll be able to see, give yourself an eyeball of, and think about whether it's the right contract for you, and some stats on whether we're able to help modify that contract for you. And then awesome. On the right, you do sort of an up and down scroll if you're logged in to see the language.
Fabulous. Thank you. Thanks so much, and for others, just let us know if any questions come up as we go along.
Okay, so I'm going to just bring us back to compensation as an item. The other things that we might think about here are, I think I just said this, whether we're invoicing weekly or monthly, and so the standard language is very, very bare. While performing services, the consultant shall be entitled to be reimbursed reasonably. Well, that sounds pretty vague. So I think the idea here is that you would first come up with a list of questions of the things that you care about, and then discuss it with your team internally to say, what are we going to do? Are we paying daily, monthly, hourly? Eventually, you'll have a standard for all of these types of things, and you'll only pay daily or monthly or hourly or weekly. But the first time around, there is quite a bit of thinking around what makes sense for the organization. Now, and then the next thing you would do is you sort of discuss it with your counterparty and see whether they're amenable to your terms. I do find that when drafting an agreement like this, the first time around, you might not have it right. But when you do have, like when you've hired about 100 people on the same contract, the little tweaks that everyone requests will help you modify it little by little till you kind of capture all those risks and interests that they're looking for. And then at that point in time, it's kind of a solid standard document with almost no negotiation, because there's nothing much that people can suggest that you haven't really thought about in advance, and that you'll either accept it or you won't, because you don't make those adjustments for really anyone else. So it would be outside of your system to do that for somebody new, and most people won't understand that. So okay, so let me just work through some of the other key points. So services, I think, is scope of work. So I would probably either look for scope of services or scope of work on the left, and it brings me to a section of the agreement called services. Fantastic, and in this case, where the language says that the services will be set out in Annex A. So everything about that is fine with me. The other things I might think about that might not be in here would be, are there deadlines? Because I think when hiring, if you're hiring for a specific purpose, you might have the need for a specific deadline, or like specific activities, general activities, who you would be reporting to. Would be issues that you might consider. I had also mentioned before that something that I would care about is whether the person is providing services to a certain standard, and I see that clause here, and so we would probably want to push something like that into the agreement, to get for the idea that if someone is hired and they don't have a minimum standard of ability, then we want to be able to say, okay, well, you said that you could do this and you're not able to. And here the language says the minimum standards as set out in the Professional Rules of Conduct of the Law Society of Canada. That's a pretty specific type of standard. Certainly, you can edit that and make it, the minimum standards of the professional group that you're working with. The only other thing I might say here is that just by reading through the commentary, you might think of other points that are ones that you want to consider, and then you would push those in as well. Thinking about the other risks that we had in our list, confidentiality is one that I always worry about when hiring. Definitely on the for-profit or not-for-profit side, you're constantly handling information that could get leaked, and if it does, it would be very embarrassing. Personal information protection is a big one. So in here, there's a very light confidentiality clause. So what I'd probably do is I would read through and think about what are the other things that I might worry about. What are the things that we're sharing? So in this case, are we sharing reports, analysis, compilations, memorandum, notes? Yeah, probably sharing a bunch of that stuff. Like we'd already thought about some of the things that we might be sharing, which included financial information or personal information. So I'm continuing to just put those comments within the draft. That's kind of how I like to draft, because I want to capture those thoughts and then check and double check to make sure that I've captured it within the clause language. And I also want to share that with the folks who I'm working with within the organization, and then probably even with the counterparty if it's a good relationship. There's no need to hide some of these points unless you're in a tough negotiation, in which case you probably want to hide your thinking. But if it's a pretty neutral negotiating point, then by sharing your risks and concerns and putting them out in the open, then it kind of makes for a pretty fast negotiation on those points if there's no real contention. And in this case, protection of financial information, personal information is probably not contentious. What might be a little bit more challenging would be something like confidentiality of the work product. Okay, that would make me wonder as the contracting party as to whether or not I'm giving away rights to materials that I might want to use in a different contract. So that's another issue that we might think about too when we think about ownership of material. So I click on the BOB for ownership of material, and that brings me to another section of the agreement, ownership of material. This clause indicates which parties possess ownership of the work product. It's an important clause to include so that there are no disputes between what work completed is owned by the contractor and what work completed is owned by the company. So seems like a pretty innocent clause, but again, like a contractor who has brought in their own methodologies and prior existing IP might have an issue with transferring all of it to the company. So the question there would be, is there any pre-existing intellectual property? Right. And then and maybe to expand on that, would the contractor have a problem sharing or transferring the IP in that material to the company? And the language that we might push in might say something like, yeah, all of the IP that's transferred in belongs to the company, which could be contentious, and obviously that's something that could be modified by the parties. And the idea would be that if there was pushback, then the party might say, okay, well, I own everything I brought into this relationship, and here I'll make a note of that. The contractor could own the IP that they brought into the relationship. And the parties might decide to specify that within the contract. What that material is. So far, so good. Maybe I'll just take another pause and see if there's any questions. And I'll also say hello to Alexandra, who has just joined. Hi, Alexandra. I don't see any questions in the chat. Did anyone have an interim question while we're going through this?
Oh, Beatrice is typing there with the question.
Okay, so I'm going to continue going through this, and I think I'll go through about 3 more topics, and then we'll bring it back for questions. Okay, so what have we thought about so far? We've thought about hiring someone. We've considered what services they're going to be providing. We've considered the compensation they'll be paid. We've considered their time period. You'll note that we haven't actually done any drafting, but I think the idea that I like to start with is that we've staged out the issues, and we're getting ourselves ready for commencing drafting. And we sort of put all the language together so that we're able to think about what the issues are. I paused on invoicing for a second because we were asking here whether the person would invoice weekly or monthly. And in the language it says that the company agrees to pay the consultant within 30 days after receipt, and the invoice will be provided after completion. So perfectly acceptable. You might decide that you would request an invoice monthly depending on the arrangement. You might ask for one at the beginning and one at the middle of the arrangement and one at the very end. So it really depends on the purpose that you're hiring for. And so we've supplied some variations on that language as well. Confidentiality we talked about, ownership of IP we talked about. Expenses, I think we had a little bit of a chat about that, and the idea was that you'd want to have some sort of cap on or maximum on the expenses, so that you're not in a situation where your compensation is $1 amount, and then you're surprised with expenses that you weren't expecting. So the expenses clause, I would usually include something like this one, which says for reasonable expenses actually and properly incurred, and I probably would also want to include some language that says that expenses are accrued in advance. So yeah, I just also wanted to bring our minds to the topic of termination of employees, because it's not unusual that you might bring someone in to the company, and then you think to yourself, well, they're not exactly the person that I wanted for whatever reason. So included in most agreements will be some sort of termination mechanism. And just doing some reading here, there's quite a bit of commentary on the things that you might think about, and so I've highlighted a bit, but I think you could definitely go through and read this. There's also, it looks like we've got a few blog articles posted on this topic, and you'll see that highlighted in blue. So it gives you some other flavor on the topic of termination. So in any case, I'm just going to comment in again some of the issues that I might think about. So termination, one would be, for a contract, would be on what notice, for what grounds. And in a contract relationship, it can usually be on immediate notice. So that's something that you might want to negotiate. And then from the perspective of the contractor, how much notice do they have to give the company? And so depending on the nature of the project, the contractor might be required to give 2 weeks notice. Or even more. To some reasonable extent, of course, because I think the longer the period, the more likely that type of clause might be tested by the courts. So you wouldn't want to say something like 6 months notice, which sounds unreasonable at first base. And on the other side as well, depending on the value of the contract, so if it's a tiny contract, then immediately giving notice is probably fine. But if it's a massive $1 million contract or something like that, then presumably the contractor has hired folks to help them fulfill that contract. So requiring something more than immediate, like a 2-week or a 1-month notice for the contractor to have the ability to adjust their team is pretty fair and pretty common. And then for what grounds? In a contract arrangement, there's probably several that are often raised, and it could be breach, bankruptcy. So if the contractor is unable to fulfill, or the company, unlawful activity. So that's a pretty common clause that I would want to include, so that I'm not, as a contractor, being asked to do something that's illegal. And same goes for the company. If the contractor is doing something that's illegal, then it's pretty good grounds for termination. Failure, and that's probably part of breach. So failure to perform would be a pretty common one, or for any reason on sufficient notice is also pretty common, and not. Not unexpected that in a contract relationship, the company can say, I'm out of money, or the project is being scrapped, or whatever, and let's just call it a day. Um, so just taking a look then at variation clause language, um, the agreement may be terminated early, um, and so there's loads of variations that we can try to include. Step one, in my mind, is first knowing what you want, and you can figure that out in a couple of ways. One is just thinking to yourself what are the issues, and talking with your advisors and the folks at your office and so on. Second is reading and research, and you can sort of like read through our materials and try to understand the levers and the issues. And then the third is experience, and just having hired a bunch of people, you'll get a sense for what the things are that you care about in those points. So I definitely encourage staging out the clause, the language that you want when you're doing this for the first time. Probably for every draft actually, and I do this for every draft, just so that you make sure you capture your risks and interests, and then subsequently start working through the clause language to make sure that it captures the points that you want. So I'm just going to walk through a couple more points. I wanted to talk about liability and what happens if something goes wrong. So
Rajah, can I just jump in for 1 second before we move on to liability? Beatrice has a question that takes us back to confidentiality a few moments ago. And Beatrice is wondering if you could give an example or a few examples of confidential personal information. And Beatrice continued by saying, as protected by the Privacy Act, for example.
yeah, so I think Beatrice, you got this right. The idea would be that so if we were concerned about confidentiality, and I have that up here, financial information and personal information. Um, so the personal information itself can be defined, and I don't know if we have a definition of it actually. I'll take a look and see. Personal. It doesn't look like I have one posted, but why don't I just make a note here that definition of personal information will be useful, probably for both parties. And one that you've noted here is that as protected by the Privacy Act, and the Privacy Act is a good place to find that definition. I think we'll post it anyway, as you've noted. But then the idea there is that when you're a contractor, you can look at that definition and say, oh, okay, this is what I can't start disseminating. I've agreed to it, and it's required by law, and it's also required by my contract. Does that help? Okay.
Well, I'll monitor and see if Beatrice has a follow-up or a response to that, and we can continue on to liability. Thanks so much, Rajah.
Okay, so liability and indemnity, I see that they're not even in the base agreement, so I mean, I think that they're fair questions to ask. Depending on the value of the agreement, people might balk a little bit at it, because if you're coming in for a small value contract and there are these massive, scary liability clauses or indemnity clauses built in, then folks might say, I don't know if I want to sign that. But the idea then is basically, as a contracting party, as a hiring party, you're probably worried that you're going to hire folks who will do some things, off track, that'll get you in trouble. And if it's an individual, then you might not be able to rely on a limitation of liability clause. But if it's another business, then you definitely would want to include something like this. And then the idea is that you can't, you don't want to be in a situation where someone says you promised X and you didn't give me that, and now you owe me. Like we put aside our team for the purpose of this contract for 4 weeks, and now you owe me 4 weeks of compensation. So I think the idea here would be a tight liability clause. what should take into account some of the realistic things that could go wrong. I'd say especially when hiring a contracting company. The other half of that would be the idea of indemnity, and indemnity is the situation where your contracting party or company goes out and does something to create damage in the world, and somebody else, a third party in the world, comes back to the company and says, "You owe me something." So they'll come to the not-for-profit and say, "You owe me something because your person did this, or your contractor did this bad thing." So we look for indemnification language. Do I have any here? Probably have a lot. Oh yeah, here we go. Looks like I have 6,000 clauses in this category. But the very first one is a pretty standard one. The contractor shall indemnify and hold harmless the company and its shareholders and employees, agents, lots of different people. Maybe too many people. I think you can't really go wrong by over-including in this case, but you might just think, like, who are we really concerned about, and then comment on those. So in this case, you'd probably want to identify the not-for-profit at the very least. So I want to just re-explain that because I think it's a confusing topic, but one that's important. And maybe an example will help. So if we hire a vendor to build a website, and that website starts spamming everybody, now we're suddenly in breach of anti-spam legislation. And whose fault is that? Because we're an innocent company that just hired a vendor that we thought knew what they were doing. So yeah, we're probably still in breach if we didn't do our due diligence. And so the idea here is that we want someone to defend us or compensate us for any damage that we might take on, any claims that we might have to pay out. And so the contractor says, yeah, okay, well, I know what I'm doing. I'm not, I'm competent. I don't think I'm going to create this type of risk for you, and so therefore I'll protect you if something bad like this happens. So I guess you could just say seeking protection from some third-party risk. Okay, so I think I'll bring us back to Q&A. My goal of the session was to walk through and talk through some of the thinking points around drafting and to stage out a solution. And really, for me, the staging is a really key part of the contract building process. It's definitely possible to get a cookie cutter agreement, and as you can see, we did that here. But the thinking through each clause and thinking about whether we capture the specific things we care about, that's sort of what you need to do to get your contract that you've acquired to the next level. And using a useful tool like this, or even just marking up an agreement and circulating it within your organization, will help you to take that contract to a point where it captures your interests and your risks. And I definitely think that thinking about what the counterparty's risks and interests are in advance really helps as well to get to a successful negotiation pretty quickly.
That's fabulous, Rajah. Thank you so much. So folks have some follow-up questions. I mean, we've covered a lot in the last 45 minutes. I really appreciated how you started with thinking about some of those questions and considerations, and appreciate as well how you've mentioned a few times, once you've done this a few times, some of those considerations will start to feel a bit more second nature and maybe be on your radar a bit more. For someone who's starting off, I mean, you've given us some really good examples to be thinking about in just walking us through those lists at the beginning. For someone who's starting out and say this is the first time that they're hiring a contractor, would you recommend they sit down with someone who can give a bit more insight into some of those considerations? Or what would be, I mean, aside from watching this webinar and drawing upon the list that you started us off with for the particular context in which someone finds themselves, what would be some tips and hints for even just that starting point of the list you made with the considerations at the beginning?
Yeah, like there's no substitute for expert advice. I think the way that I kind of think of it is if you can kind of go into a meeting with your questions staged out, and possibly even use a tool like this to start your understanding process and really onboard yourself as to what's in a contract, and then walk through and like think about whether the clauses match your risks and interests. Then you're possibly 70% of the way towards getting your draft completed. Whereas if you start from scratch, then that whole staging and thinking process is part of that journey for you and your advisor and your lawyer or whoever you're working with. So it can be time consuming and expensive. And so I think the goal that I'm trying to achieve is that you're possibly 60 to 80% of the way towards knowing what you want before you even have that first meeting.
Which is absolutely,
maybe 100%
yeah,
depending on the complexity.
it's totally phenomenal, especially for a not-for-profit that's starting out, to have a tool to really get you to that 60, 80, even 100% point with some of these considerations, especially for folks who aren't super well versed in the legal world. That's such an incredible tool. And I loved watching as you kind of worked your way through it. Just, a number of times heard you say you just push them in, and seems to be so user friendly to once you kind of get used to it, to be searching for the clauses and then seeing what works for your particular agreement.
Yeah, I think if you're willing to take on the time to learn the language, it'll serve an organization well over the course of your career. Whether you stay with one organization or move around. Contract language it's a language, like it's English, but there's a rhythm to it, and it's one that you can kind of onboard to yourself. You just need to go through and sort of understand the framework of it and the levers. And so I think that's like I said, that's my goal, is that someone going into a meeting isn't going in clueless. They'll have a good idea, even if they think that they're completed and they have the contract ready to go. They can go in with like their top 10 questions of what they want to verify before they go into that meeting.
Fabulous.
I should point out, and I didn't point this out, we've included a collaboration feature as well, so that all your comments can be shared with with the rest of the folks in your organization or even your counterparty. So then the idea then is that you're staging out your thinking, but then you're able to retain that same thinking for the future, or even within this current negotiation, or down the road in a future negotiation, so that the onboarding, the learning process doesn't disappear after one draft; it stays with you.
And that actually touches upon a follow-up question that I have, which is, I see that finalize button you've got there, and once you finalized an agreement, say, what are the steps, or is it easy to go in and edit if you realize you've missed something, or there's been
it finalizes. It looks like I've been finalizing like crazy, and I have no downloads remaining, but the software allows for three unlocked documents per month.
Okay.
As you can see here, and so finalize will give you a Word version that you can do your final edits to, and then send for signing.
Fabulous. So what about those of you who? Yeah, what about those of you who are logged on live here? Do you have any questions? Beatrice did have a bit of a follow-up around the confidentiality piece, wondering if I think you could give examples about what one can and cannot respond to in terms of confidentiality of personal information.
Oh, okay. That's a good question, actually, Beatrice. I'm going to make a note to post, and I have a letter that I send out, a letter for exiting employees.
Hmm.
So, I'll make a note to post that on CloudTown. But it is useful when someone leaves your organization to send a letter saying these are the things that you shouldn't, that by your contract you're not permitted to share with people in other organizations that you work with. And it can be like ones that I think would be sort of a no-brainer would be personal information or financial information. If we're a competitive business, then it would be business plans or sales contacts, customer contacts, marketing plans, like anything marketing related. Like it could be software design or software development. So I think specifically this is probably a contextual thing, and within the clause, if I look at confidentiality, I'm just going to pop into it right now. And I wrote financial information, personal information. What you probably would want to do is actually specify what confidential information is, like create a definition for that for the topic. And confidentiality, let me see, definition. That's a pretty broad one. Technical information, financial information, right? So we can just sort of push in stuff that we think is important. And it doesn't have to be super long. Like you can see this is pretty deep. It could just be no financial information or personal information without specifying what that is, and then sort of leave it broad. But if you know that if you know that you've worked together to create profits forecast, sales or commission discussions, and funding value, all this other stuff, then you might say, well, and you did this work for us, and it's super confidential. So don't forget about that, and we definitely treat it and value it as confidential information.
Fabulous. So Beatrice, I hope that provided a good follow up there, and appreciate, Rajah, that you've been kind of making notes as well on some follow up stuff to pass on. Yeah. Awesome. Beatrice says, "Yep, thanks." So
You're
I'm not
welcome.
sure if anyone else has any questions. Rajah, I so appreciate that you've walked us through kind of from start to close to finish, what that looks like, and then even going into that finalizing and the downloading of a Word document, so that one can end up with an agreement, is just incredible. Thank you so much. And I know that this time together, this hour, as well as the recording that people will be able to access, will provide a really helpful tool for a starting point, for some of those legal considerations, and even just how to get started in hiring a contract employee. This has been an incredibly helpful hour, and I don't see anyone else typing. So I wonder if folks have any other questions. Please take a moment to type them in now. And Rajah, are you open to emails? Anyone following up with you with particular questions?
Definitely. So if you think of something later today that you wanted to talk about, just let me know. Just a reminder that we're not providing legal advice, not permitted to do so, unless we're in a lawyer-client relationship, and our insurance company wouldn't be happy if we did. So the talk today is strictly legal information, not legal advice. If you do have questions, feel free to contact me separately, and I think Lauren will provide the information for that.
Fabulous. Yeah. So can send us a note, and we'll get you in contact with Rajah. But all of you as participants in this webinar will receive a follow-up email after the fact with the link to the recording of this session. So I hope you've captured a lot during this hour, but don't feel like you're going to leave this hour and whatever you've missed is gone forever. You'll have the ability to view this again, and as I mentioned at the beginning, also pass it on to others in your organization or with whom you're working to collaborate on that. And if you would like, if you weren't on the uh, email list, if you haven't registered for this webinar in advance but would like a copy of the recording, you can send us an email and I'd be happy to get that to you. Or you can log on to our Edge UCC, Edge United Church of Canada, YouTube page where we have the full library that we're building of all of the social enterprise webinars. Please also check out the webinars page on the Edge site for a number of our upcoming webinars. So Kimberly has said thanks for a very informative session, and I'd love to echo that. Thank you, Rajah, so much for taking the time to be with us today. Thank you to our participants, and good luck in each of the steps of going about that social enterprise and collaborating on best practices. So thanks, Rajah, and have a great day, everyone. Take care.
Thank you very much. Take care, everyone. Bye-bye.